Good morning, ma'am.
గుడ్ మార్నింగ్ మేడం.
గుడ్ మార్నింగ్.
సార్ వచ్చేస్తున్నారు. ఓపెన్ చేస్తాను సార్. మేడం వినిపించకపోతే రీస్టార్ట్ చేయండి. మళ్ళీ
ఇప్పుడు మేడం అంటే కామ్ గా ఉంటే నేను లేట్ గా వచ్చాను మేడం. అది
Okay.
Yes,
అందుకని
am I audible?
ఎస్ సార్ యూఆర్ ఆడిబుల్. కనిపించట్లేదు మీ ఫోటో. ఎస్ ఇప్పుడు కనిపిస్తున్నారు.
Yes. So,
గుడ్ మార్నింగ్ సార్.
there is one more aspect while you are actively practicing, that is jurisdiction of courts under certain special enactments. We have already just touched upon the fact that depending on the value of the suit and the nature of the commercial transaction, commercial court may get jurisdiction, even though it is a suit that can be filed before a civil court. Similarly, we have got family courts which have got jurisdiction on specific aspects between spouses, basically. Section 7 of the Family Courts Act is important for you when you want to file a case which is within the jurisdiction of family court and which relates to a family dispute, and it is necessary to know what type of matters can be taken before the family court, and once the family court gets jurisdiction, the other courts lose jurisdiction. Therefore, whenever there is a family court, let us say Guntur or Vijayawada or Visakhapatnam, there is a family court, and the family court will have certain jurisdiction, and within that jurisdiction, Section 7 decides the issue relating to jurisdiction when the dispute is between mostly spouses and sometimes between family members. Let us see what Section 7 says, because Section 7 has got several specific subsections relating to jurisdiction. Subject to the other provisions of the Act, a family court shall have and exercise all the jurisdiction exercisable by any district court or any subordinate civil court under any law for the time being in force in respect of suits and proceedings of the nature referred to in the explanation. Therefore, where there is a family court, it will have jurisdiction exercisable by any district court or subordinate court, and after what I have read, and be deemed for the purpose of exercising such jurisdiction under such law to be a district court, or as the case may be, such a subordinate civil court for the area to which the jurisdiction of the family court extends. So it will be deemed to have jurisdiction for the purpose of dealing with such cases. Therefore, A, B, the in between, it is not R or anything else, and therefore, family court will have and exercise all the jurisdiction exercised by any district court or subordinate court and under any law for the time being in force. In respect of suits and proceedings of the nature referred to in the explanation, and be deemed for the purpose of exercising such jurisdiction to be a district court or as the case may be, such subordinate civil court for the area also. Therefore, when once the family court gets jurisdiction, it will get jurisdiction of district court as well as any other subordinate court. Please remember that when once family court jurisdiction is attracted, the question of recognizing it as a district court, cadre, family court, and then going to a subordinate court for the purpose of other reliefs, thinking that it can be filed only in the subordinate court prior to the family court establishment. That is not correct. For all practical purposes, family court will deal with all cases, whether they were previously filed before any subordinate court, whether they could have been filed before any subordinate court or else. Therefore, district court and all other subordinate courts, whatever matters are now being listed under explanation, they will be dealt with by family court, and family court is deemed to have jurisdiction. The explanation, the suits and proceedings referred to in the subsections are, subsection are suits and proceedings of the following nature. Namely, a suit or proceeding between the parties to a marriage for a decree of nullity of marriage, within brackets, declaring the marriage to be null and void, or as the case may be annulling the marriage, or restitution of conjugal rights, or judicial separation, or dissolution of marriage. Therefore, any suit of such nature or proceeding, it shall be filed in the family court only when it relates to any of the reliefs you may come across under any act relating to marriage, that is Hindu Marriage Act or Divorce Act or Special Marriage Act or whatever it is. And then a suit or proceeding for a declaration as to the validity of marriage or as to the matrimonial status of any person. What is the difference between A and B? Let us see the wording, because if we compare the wording, the concept will be embedded in our minds. Yes, so I am again reading A. A suit or proceeding between the parties to a marriage for a decree of nullity of marriage. And nullity of marriage is further explained by noting in the brackets, declaring the marriage to be null and void, or as the case may be, annulling the marriage. Now, for a decree of nullity of marriage or restitution or judicial separation or dissolution. So all these things will come under section explanation A. What is the difference between A and B? B is a suit for proceeding for a declaration as to the validity of marriage or as to the matrimonial status of any person. Now, you know about section 34 of Specific Relief Act. It provides for a suit for a declaration that I am the wife of so-and-so, or that I am not the so-and-so is not my husband. All those declarations can be filed with regard to the status of a marital status of a person. Now, that is here provided. Suit or proceeding for a declaration as to the validity of marriage, because in the In explanation A, all the reliefs that can be granted, say under the Hindu Marriage Act or other acts relating to marriage, they are given. Now here specifically, the suits are proceeding for a declaration as to the validity of marriage or as to the matrimonial status of any person. The implication of explanation B is simple. If there is no family court, such a suit will be filed as an original suit in the court having jurisdiction. Such a suit cannot be filed under Hindu Marriage Act or other enactments. Therefore, that jurisdiction relating to civil courts is also given to the family courts. Now, clear? The first explanation relates to the ordinary reliefs that are sought in a marital dispute, either under the Hindu Marriage Act or other enactments relating to marriage. B relates to certain type of suits which were hitherto filed. Hitherto means previously filed in civil courts regarding the status, marital status of a person. And also validity of the marriage. Now suppose there is a first wife. Second wife is also claiming to be the real wife, and second wife is also claiming certain benefits relating to husband. Then the first wife will say, she is not the legally wedded wife of my husband. Or the second wife may come and say, I am the legally wedded wife of my husband. Therefore, all these issues relating to validity of marriage or as to the matrimonial status of any person, they come under Family Courts Act. Then C, a suit or proceeding between the parties to a marriage with respect to the property of the parties or either of them. So, a suit or proceeding for a between the parties to a marriage with respect to the property of the parties of or of either of them. So, there is a property dispute between them also, parties to the marriage, then the issue will come before family courts. Let us say the wife says, my Sridhana property is kept in the locker taken by my husband and he cannot operate and he is not allowing me to take that Sridhana. Then family court, wherever it is having jurisdiction, it will have jurisdiction. Just 1 minute. There are several types of property disputes which between the spouses which may arise. Let us say my husband has forced me to execute a gifted in his favor in respect of the property which my parents have given, and he is I am entitled to cancellation of the deed. He initially said that he is taking a loan for some starting some business, and he wanted the property to be in his name, and now he has left me and my property is taken away by him. So this is one area where there may be disputes between the spouses in relation to the property. And then a suit or proceeding for an order or injunction in circumstances arising out of a marital relationship. For an order, I think it must be off injunction. There may be a type mistake. Please verify in your edition of the Family Courts Act, Clause D.
Sir, you can see on screen, sir.
R అనే ఉంది. I verified in the Google also. It is like
Yes, sir.
R only.
Yes, exactly, sir. I'm sharing the screen. It's showing R.
For an order, or injunction in circumstances arising out of a marital relationship. Therefore, it is a suit or proceeding for an order or injunction in circumstances arising out of a marital relationship. Let us say my husband should not marry again. My marriage with him is subsisting. All these things, and then a suit or proceeding for a declaration as to the legitimacy of any person. The word used is any person. And then a suit or proceeding for maintenance. We have already seen that. You can file a suit for maintenance under the Hindu Adoptions and Maintenance Act. And then a suit or proceeding in relation to the guardianship of the person or the custody of or access to any minor. So guardianship issues are also entrusted to the family court. Subject to the other provisions of this act, a family court shall also have and exercise jurisdiction exercisable magistrate under 125 CRPC. Such other jurisdiction as may be conferred on it by any other enactment. Therefore, this is the scope of Section 7 of Family Courts Act. Now I will give you certain case law because it relates to jurisdiction. Where the family court will not have jurisdiction also, there are certain judgments which I have noted. They are up to date at least up to the end of 2021. Please note down those judgments. Family court has no jurisdiction to try suit involving disputes between brothers and sisters. P. Srihari versus P. Sukanya. This is a judgment of AP High Court. But as I told you, I noted this from that particular general, DMC. DMC 2001-2. 135, page number 135, AP. The journal is like this. 2001 DMC, second volume, 135 AP. Second volume will be noted as Roman 2. 1 and bar above and below. And then this, you please also note this. What about the appearance for every adjournment before family court? Because family court basically parties have to appear, and advocates can appear only with the permission of the family court. Kamal S. Padukone versus Kamal S. Padukone versus Principal Judge Family Court. AIR 1999 Bangalore 427. AIR 1999 Bangalore 427. As I told you, Some of the judgments under family courts will be of other high courts, but they will be detailed judgments and they may be having reference to some Supreme Court judgments. And then proceedings for custody or guardianship of minor by grandparents. Please refer to AR 2016 Gujarat. AR 2016 Gujarat, page number 189, division bench. And then jurisdiction of family court explained. Jurisdiction of family court explained. AR 2016 Kerala 75 division bench. AR 2016 Kerala 75 division bench. You can find these all India reporters in some bar association libraries, or you can browse, or if somebody is having a online AR subscription also, you can go and take it. Please don't worry about it. And then reliefs under DV Act can be granted by the family court. AR 2010 Orissa 68. AR 2010 Orissa page 68. And then sometimes medical examination of a party may become an issue, either with regard to potency or some such thing. The medical examination of a party and jurisdiction of family court. AR 2010 Supreme Court 1240. AR 2010 Supreme Court page 1240. And then suit by parents that marriage is void is not maintainable before family court, because basically you see the wording is between parties to a marriage. So if one of the spouses remaining outside the family court and simply getting a suit filed before the family court that with regard to the validity of the marriage, basically they are not the persons who are concerned with the validity of the marriage, and even otherwise that such a suit will not be maintainable before family court. Suit by parents that marriage is void is not maintainable before family court. AR 2014 Rajasthan, AR 2014 Rajasthan 89, division bench. Division bench. With regard to the nature of legislation by a Family Courts Act, it is a beneficial legislation with reference to 125 CRPC, and it also relates to certain rights created under Article 23, 24. 23 is traffic in human beings, 24 is child labor. Please see 2020, 2020, within brackets 2ALT, Andhra Law Times, Civil, page number 410, Supreme Court. Page number 410, Supreme Court. And then Family Courts Act and CPC Order 13, Rule 3.4. That is with regard to documents, etc. 2020, volume number 6, ALT, Andhra Law Times, 409, judgment of Telangana High Court. Because I told you that the case law is updated up to the end of 2021. You have to verify the case law subsequent to 2021. If possible, I will verify it today or tomorrow and then give that case law also if there is any change in the interpretation given by the higher courts. And then what is the ordinary residence of minor under Hindu Minority and Guardianship Act Section 6? All these are important for deciding jurisdiction of the court in which you have to file. Even if it is family court, which family court? So ordinary residence, how it should be interpreted? That is 2020 3 ALT Andhra Law Times 187. And then Family Courts Act Section 13, appearance of parties for conciliation. Suppose if they don't appear for conciliation, what happens? 2019 2 ALT page 1. 2019 2 ALT page 1. And then as I told you, the Supreme Court has also commented that negotiated settlement is better in divorce and custody matters. Suppose your party wants conciliation and you want not just a formal conciliation meeting for on one occasion, you want a detailed conciliation effort between spouses, then you can cite this decision. 2019 2 ALT Andhra Law Times 279. 2019 2 ALT 279 Supreme Court. Why you please go through this judgment. The other side may simply say, no, we are not for settlement, but still you can urge before the court that an effort can be made to settle the issue. In cases where your party is interested in such settlement, and you also think that it is necessary to have such, because
Sir, please repeat. Sir, please repeat the.
2019 2 Andhra Law Times 279 Supreme Court.
Thank you.
So, because what is the difference between conducting of a case in a court and a conciliation? The basic difference is sometimes if the advocate is trying to override the opinions and also the inclination of the party to participate in conciliation, and if your party says if conciliation is the matter will be settled, please see that the other side comes to conciliation. Then you have to urge before the court that the Supreme Court has said so. And then with regard to proof of documents, previously there was a discussion on this because Section 14 of the Family Courts Act and family court can admit certain documents with regard to which may not be admissible under the Indian Evidence Act. Please go through a division bench judgment of AP High Court. 2018 3 ALT Andhra Law Times 2018 2018 third volume Andhra Law Times 691 division bench. And then Family Court Act, court fee to be paid regarding declaration as LRs and for pensionary benefits. 2016 1 ALT page 14. 2016 1 ALT page 14. Because we have seen how the family court will have jurisdiction with regard to the property of the parties to the marriage. Therefore, what is the court fee to be paid? That is 2016 1 ALT Andhra Law Times page 14. And then negative declaration of status of wife maintainable under Section 7 of Family Courts Act. We have seen explanation. all the reliefs relating to marriage and suits for declaration. This is 2016 3 Andhra Law Times 53 Supreme Court. 2016 3 Andhra Law Times 53 Supreme Court. I'm telling you a practical issue. Somebody in the cadre of district judge will be posted to the family court. All these aspects may not be within the knowledge of the judge who is dealing with the Family Courts Act. Because these are all judgments which I have noted down, some more than 50 judgments relating to family court after going through all the digests. Officer may not be having such time, he may not be maintaining those judgments because he was dealing with other cases elsewhere, or he is newly promoted and posted in the family court. Therefore, in relation to jurisdiction of family courts, you should have the case law, you should know what is the ambit of section 7, what is the purport of the words used therein, what is allowed before the family courts and what is not allowed. These are all very important issues because when once you can convince the court through these judgments, then other matters will be easier. Don't be under the impression that judge knows the law. Please leave that presumption aside. These are the various reasons where the judge may not be aware of all these things. Therefore, if you have judgments in relation to the jurisdiction or absence of jurisdiction of family court, then you will be very successful in getting a case registered before the family. And otherwise also, after this case law is over, I will just deal with the procedure to be followed in family court because there will be several sensitive issues. I tell you, in a case which is running in Telangana, the wife simply said, marriage is not consummated. They lived for about 1.5 years together after the marriage. There is no such mention in the FIR given by her on 498. There is no such mention in the notice issued by her. She simply said marriage is not consummated. She never said anything about the husband being impotent. She never said anything about the reason for making such an allegation. It is made only to show to other persons, if at all she gets a divorce and wants to marry, then she will show it to somebody else. No, marriage is not consummated. This is what I have written in the court. Now, on one of the adjournments, advocate began shouting that the respondent is impotent, which is not a plea of the other side at all. Therefore, you should be very, very careful as to what is happening in the family court, and you may have to seek in camera trial, which is provided in the Act, in case where the allegations are of sensitive nature and affect the further marital prospects of one of the spouses. ఈ ఫ్యామిలీ కోర్టు మ్యాటర్స్ లోనే ఒకళ్ళ మీద ఒకళ్ళకి విపరీతమైన కక్షపూరితమైన ధోరణి ఉంటుంది కొన్ని కేసుల్లో. They not only want to dissolve the present marriage and but they also want to bar the future prospects of the other side. And then Family Courts Act Section 7, Order 39, Rule 1 CPC. (2014) 3 ALT, 2014 3 ALT, page 59, Division Bench. Now, in this regard, I will also read Section 10 because it's incidental. Section 10 of the Family Courts Act. Subject to the other provisions of this Act and rules, the provisions of CPCA and of any other law for the time being in force shall apply to the suits and proceedings other than the proceedings under Chapter 9 of CRPC, that is 125 CRPC proceedings, before a family court, and for the purpose of the said provision of the court, family court shall be deemed to be a civil court and shall have the powers of such court. Subject to the other provisions of this Act and the rules, the provisions of the Code of CRPC or the rules made thereunder shall apply to the proceedings under Chapter 9. 3 is important. Nothing in subsection 1 or subsection 2 shall prevent a family court from laying down its own procedure with a view to arrive at a settlement in respect of the subject matter of the suit or proceedings or at the truth of the facts alleged by the one party and denied by the other. And 11 says, proceedings may be held in camera if the family court so desires. Family court itself may opt for a in camera proceeding and shall be so held if either party so desires. And then assistance of medical and welfare experts is section 12. Therefore, because CPC is made applicable, you please note this decision. This is also a division bench decision. Why I am saying that it is a division bench decision, unless it is again set aside by a larger bench, it will hold the field. That is 2014 3 Andhra Law Times, page 59, division bench. And then with regard to scope of section 7, please note another judgment, 2014 3 ALT 615. 2014 3 ALT, page 615. And then with regard to section 7 and 8 of the Family Courts Act, 2014 1 ALT, page 396. Because 8 excludes the jurisdiction of the family court, where family court is declared to have jurisdiction under section 7. And then applicability of Order 1, Rule 10 CPC in proceedings before the family court. 2014 2 ALT, Andhra Law Times, 2014 2 Andhra Law Times, page 220. With regard to section 7 and 8 of Family Courts Act, 2014 1 Andhra Law Times, page 396. 14 1 ALT, page 396. And then section 7 and 19 of Family Courts Act, section 114 and Order 47 Rule 1 CPC, 2014 2 ALT, page 422. 2014 2 ALT, page 122. Nineteen is appeals. So with regard to appeals and review also, there is a judgment. Please go through that. And then now legitimacy of the child may be one of the issues between the spouses, but legitimacy of child can be gone into only when marriage is established. That is, with regard to the scope of section 7, explanation E and G, 2004 within brackets 5 Andhra Law Times, page 1 Supreme Court. page 1, Supreme Court. And another judgment on the scope of Section 7 of the Family Courts Act. 2013 1 ALT Andhra Law Times, page 18. Page 18, this is a judgment of the Supreme Court. And then there are two judgments with regard to the jurisdiction of family court in guardianship issues. That is 2013 5 ALT 745, 2013 5 ALT 745, and then 2013 2 ALT, 2013 2 ALT Andhra Law Time 644. This is a division bench judgment. 2013 2 ALT 644 is a division bench judgment. And then Family Court Act Section 7. 2012 3 Andhra Law Times 803 division bench. These are all several judgments relating to the interpretation of Section 7 and jurisdiction of family court. And another judgment, guardianship issues, that is also dealt with in 2012 3 ALT 803 division bench. 2012 3 ALT 803 division bench. And then what is the status of the family court judge? That is 2011 1 Supreme Court cases 252, because he can handle any matter with regard to matters which can be dealt with by district court or any subordinate court, just for the sake of knowledge. And also sometimes the family court judge himself or herself may entertain a doubt. That is 2011 1 Supreme Court cases 252. Somehow, because of going through all the digests, some 30-40 digests, I could not note the names of the parties, but still you can easily access them in the Google. And then appearance of parties in Hindu Marriage Act proceedings. Suppose Hindu Marriage Act case will also be filed before the family court. 2011 4 ALT 318. 2011 4 ALT page 318. And then with regard to 125 CRPC proceedings before family court, 2010 3 ALT, 2010 3 ALT criminal page 50. 2010 1 ALT criminal 125. 2010 1 ALT criminal page 125. Section 7, explanation C. Suit by wife relating to property of husband which was already alienated. That is 2010 6 ALT 75. 2010 6 ALT page 75. And then Family Court Act Section 19 Clause 4. Whatever it is, maybe.
Sir, kindly repeat, sir. Kindly repeat, sir.
Family Court Act, burden of proof when husband denies marriage.
Prior to this, sir, prior to this,
Husband denies
after
marriage.
this suit, you have referred to the case, property already alienated. After that, you said one reference,
That
citation.
is 2010 6 ALT page 75.
Yes, sir, that I noted.
Suit by wife relating to properties of husband which were already alienated. 2010 6 ALT page 75.
After that, sir, after that.
After that, burden of proof when husband denies marriage. Divorce and matrimonial cases 2021 page 166.
ALT, sir.
No, this is divorce and matrimonial cases. I told you a separate journal with regard to these aspects. You may find it in the High Court, or you just browse for it. Then I will also try to get that. Divorce and matrimonial cases 2021 page 166.
Okay, sir. Thank you, sir.
And then any issue relating to maintenance to major daughter under 125 CRPC. Maintenance to major daughter. (2021) divorce and matrimonial cases. 2021 divorce and matrimonial cases. First volume, page 324. And then with regard to shared household under the DVC Act, which may come before the family court also, as well as the magistrate court where there is no family court. Shared household under DVC Act. Satish Chandar Ahuja versus Sneha Ahuja. Satish Chandar Ahuja versus Sneha Ahuja. Volume number 3, 2020 DMC, that is divorce and matrimonial cases, 453 Supreme Court. 453 Supreme Court. Because there is cause title, you can easily access this judgment. Then with regard to 125 CRPC proceedings before the family court, Abhilasha versus Prakash. Abhilasha versus Prakash. Volume 3, 2020 divorce and matrimonial cases, 265 Supreme Court. 265 Supreme Court. And then with regard to visitation rights. Visitation rights means visitation with regard to the minor. He may be in the custody of the mother or father. Other spouse will claim visitation rights. That is volume 1, 2020. Divorce and matrimonial cases, page 210. Page 210, Division Bench, Rajasthan. Now, I told you that wife is entitled to lead life at par with the standard of husband when it is granting of maintenance, pendant-alike. That is Part 1, 2020, divorce and matrimonial cases, page 76, Division Bench, Tripura High Court. And then marriage expenses of daughter, Hindu Marriage Act, Section 20, Volume 1, 2020 DMC, page 741. We discussed the Hindu marriage expense of daughter under the Hindu Adoptions and Maintenance Act, and it is under Hindu Marriage Act also under Section 20. And then please note one judgment of the Supreme Court. Volume 1, 2019 DMC, page 774. Volume 1, 2019, DMC, page 774, Supreme Court. In this case, the monthly salary of the respondent was between 30 to 35,000. And 8,000 to wife was granted and 2,000 each for minor children was granted. This judgment will contain certain directions with regard to the quantum of maintenance. Please try to browse it in 2009 Supreme Court, because all the judgments of Supreme Court are now uploaded in the official website of the Supreme Court. You can verify in the 2019 judgments. And then section 9, matrimonial disputes, court has to involve in process of conciliation. That is also a Supreme Court judgment. Maybe already we have noted that, no problem.
Sir, excuse me, sir. This minor children got 2,000 each. Is it 2009 or 2019, sir?
2019.
Thank you, sir. Thank you, sir.
And then overriding effect of family courts over other enactments. Overriding effect of family courts or other laws. Balram Yadav versus Gulmania Yadav. AR 2016 Supreme Court, page 2161.
Sir, please repeat, sir.
AR 2016 Supreme Court 2161. Overriding effect of family courts over other laws. Balaram Yadav versus Fulmania Yadav. And then what should be the approach of the family court judge while conducting cases? Shamima Farooqi versus Shahid Khan. And then what happens if there is already a judgment with relation to the spouses in a foreign court? That is Surya Vadanan versus Surya Vadanan. SURYA, Surya, VADNAN, Vadanan versus State of Tamil Nadu. AR 2015 Supreme Court, page 2243. And then jurisdiction to set aside decree passed by family court of another place. That is AR 2015 Punjab and Haryana, page 83. AR 2015 Punjab and Haryana, page 83. And then with regard to the procedure to be adopted by family court, AR 2015, Delhi, page 53. And then Shyamala Devi versus Sarala Devi. Shyamala Devi versus Sarala Devi. Declaration of status as legally wedded wife. Judgment of Kerala High Court. Reported in 2009, second volume, DMC 667. So these are some of the judgments relating to family court, jurisdiction, etc. And please note another judgment. Custody of minor, jurisdiction of family court, AR 1993, Karnataka, page 203. AR 1993, Karnataka, page 203, division bench. And also AR 1991, Karnataka, page 10. And then whether evidence can be allowed through Skype. That is judgment of AP High Court rendered in 2016. I will give you the exact citation tomorrow. And then suit by wife to distrain husband from releasing house property. Suppose he has a share along with his brothers. He is trying to release his share to the other brothers. That is maintainable before this family court. Suit by wife to restrain husband from releasing house property. AR 2000 Madras 300. AR 2000 Madras page 300. Family courts can evolve their own procedure. AR 2011 Supreme Court page 848. AR 2011 Supreme Court page 848. And what is the court fee to be paid on ancillary relief before family court? Court fee on ancillary relief before family court. Judgment of Justice Subhash Reddy, 2016 1 ALT page 14. Two 2016 1 ALT page 14. So these are some of the judgments. Because we have only noted the judgments, please go try to access some of them. Browse in the Google and you will get the answers. Once again, when you are reading going through any journal or browsing, you please give importance to judgments which relate to jurisdiction of a court. whether it is Family Courts Act or any other enactment, you please note down jurisdiction aspect on in territorial jurisdiction and exclusion of jurisdiction, all these things. So, madam, I am today leaving meeting at this stage.
Okay, sir, you can.
Okay, thank you.
Thanks a lot, sir.
Small doubt, sir.
Yes,
Is there any immediate relief for the custody of the minor children in our Family Court Act or in any sections of laws, sir? Immediate relief for the minor children
do
who
you have,
are,
do you have commentary under CRPC?
yes, sir.
CRPC commentary on the దగ్గర?
Only, sir.
You please go through the commentary under 97 CRPC.
Yes,
You
sir.
will get the answer.
Yes, sir.
Because Supreme Court said, even in proceedings under 97 CRPC, where you think that the child is wrongfully restrained, then 97 CRPC can be invoked.
Yes, sir. Thank you, sir.
And I will give you a detailed answer tomorrow.
Thank you, sir. Thank you, sir.
Thank you so much, sir. Good day to you all.